Saul, thanks so much for being with us right now. What is your group asking the courts to deny in regard to the Fairy Creek injunction?
Well, as you know, the company, Teal Jones, that successfully sought the earlier injunction, is now seeking an extension of that injunction, the current one ending at the end of this month. They're looking for an extension of 1 year. We are disputing it on several grounds. Some of those grounds are what the court recognizes as clean hands. In the application of the first of the injunction, in the enforcement of that injunction, there have been, in our view, some violations of the terms of that injunction by Teal Jones itself. This has to do with towing cars illegally, the use of security services not mentioned within the injunction proceedings and so forth. But the most important of all, from our point of view, is that one of the respondents here is arguing an entirely different and novel approach to dealing with injunctions. As you probably know, injunctions, there is a test that was set by the courts. And the test requires, first of all, that there's a valid reason for the court to meet on this dispute. Second of all, the consideration of which party is experiencing irreparable harm. And thirdly, on balance of convenience, which party is harmed more. So on that basis, respondents like ourselves, environmental organizations and others, really, frankly, have no valid defense, because what happens is that the decision is made on financial terms alone. That is, who is hurt most financially, and usually the company can establish that it has been harmed by the actions of the other side. And that on balance, the harm is experienced by that party and the injunction is authorized. What is failing in all of this is any consideration of the public interest or environmental or climate change considerations and the central role that deforestation of ancient forests have in terms of climate change. Because in our latitudes, the forests, especially old forests, sequester and store more carbon than any other source, both in the trees and in the subsoil. So our argument is that the court should be considering a fourth test, and that is the test of engaging the public interest when considering harm, irreparable harm, and balance of convenience, as it's called. This should be the fourth test, especially in terms of that the federal government has passed a motion, for example, that we are in a climate emergency. So given that, we're saying we should be entitled to a fourth test, which is the test that I've just described. And we feel that on the basis of that, with 85% of British Columbians supporting additional protection of the old growth, that we should win on that basis. So that is the novel test that we're asking the judge to implement. Since it is innovative, as a precedent-setting action, of course, it will be up to the judge to decide to hear that or not. But that is the gist of it.
Saul, recently Teal Jones accused protesters of disregarding the wishes of the local First Nations. What do you say to that?
It's a very interesting question, actually. We are there at the invitation of the elder Bill Jones, whose traditional territory is Fairy Creek, which is the central area that began all of this issue. That this is his traditional homeland. He has invited us to come into that territory and to defend these lands. The request by the Pacheedaht chief, because basically their band council is dysfunctional, so it's fundamentally the chief that we're dealing with. And the chief has, yes, he has asked us to leave, but we feel that we're serving a higher purpose by protecting these lands so that when and if land claims are settled, and there is a treaty process that's almost completed for the Pacheedaht First Nation, that they will still have the standing forest with which they can make a determination as to its future.
So, Saul, in early September there will be the hearing. Why is it important that Teal Jones' injunction in Fairy Creek and not continue?
It should not continue because, for the reasons that I've given, that even using within the test that we talked about harm, that on balance, the greatest harm is what is happening to the forest and to ourselves and to the public interest and public opinion. That should be how these decisions are made. And I think that on those grounds, we would come out, we would win on those grounds. The injunction would be overturned.
Well, interesting days ahead, Saul. We'll see what happens, but we certainly appreciate you taking some time for us here today.
Thank you very much for having me today.